If you're a hardware owner and you haven't heard about the major administrative act signed in July 2025, you need to pay attention right now. Because on January 1st, 2026, the biggest change to federal hardware law in almost a century takes effect. And it could save you hundreds of dollars while opening the door to challenge the entire national regulatory framework in court. Are you subscribed? Because what I'm about to explain is the most consequential piece of federal legislation passed in recent decades. And 90% of owners still don't understand what it means for them. Hit subscribe now so you're ready when January 1st hits. Here's what just happened. On July 4th, 2025, the leadership signed into law a major reconciliation bill, often called the Broad Administrative Reform Act. This is a massive omnibus bill covering everything from fiscal policy to national security. But buried inside this 1,000-plus page legislation is Section 70436. And that section permanently eliminates the $200 federal processing fee for specialized attachments, short-barreled items, and other restricted equipment. The effective date was January 1st, 2026. That was just a few months ago for those watching this now. Let me explain what this means. Since 1934, the National Regulatory Act has required anyone who wants to own a specialized attachment or specific short-form hardware to pay a $200 fee to the federal government. In 1934, $200 was equivalent to about $4,500 in today's money. It was designed to be prohibitively expensive, a financial barrier to your constitutional rights. For the past 91 years, that $200 fee has remained unchanged. If you wanted to acquire a specialized attachment, you paid $200. If you wanted to assemble a short-barreled item, you paid $200. If you wanted to register 5 attachments, you paid $1,000. That fee is now gone for those items. Starting January the 1st, 2026, the fee is $0. Now, before you think this means specialized attachments and short-barreled items are totally deregulated, let me be clear. The registration and approval process is still in place. You still have to fill out the standard administrative forms if you're acquiring an attachment from a distributor. You still have to submit fingerprints. You still have to pass a background check. You still have to wait for federal approval, which currently takes a few months. What's gone is the $200 payment. That's it. But here's why this is massive. First, it removes a significant financial barrier. $200 might not sound like a lot to some people, but when you're acquiring an attachment that costs $400, adding another $200 in fees means you're paying 50% more. And if you want multiple attachments for different hardware, those $200 fees add up fast. Second, and this is the big one, eliminating the fee creates a constitutional vulnerability for the entire regulatory act. Let me explain why. The National Regulatory Act of 1934 was passed under the legislature's power to tax. The High Court upheld the act in a landmark 1939 case by saying it was a valid exercise of that taxing power. The registration and transfer requirements were justified as being an aid of that tax. But what happens when there's no tax? If there's no revenue being generated, can the registration requirement still stand? Multiple advocacy organizations say no, and they're suing the federal government right now to prove it. Poems 1. If you're finding this helpful, imagine what you'll learn in my next video where I break down the pending lawsuits that could eliminate the Regulatory Act entirely. Subscribe now so you don't miss it. Let me walk you through how we got here. In early 2025, the current majority controlled the House, the Senate, and the White House. The leadership wanted to pass his domestic agenda in one massive reconciliation bill. That's a budget bill that only needs a simple majority in the Senate instead of a supermajority. It can't be stalled by procedural delays, so the majority started drafting what became known as the One Big Beautiful Bill. The original House version included the essential safety protections for hearing. That's legislation that would have completely removed specialized attachments from the restricted list and treated them like regular hardware. No fee, no registration, no fingerprints, no waiting period. Just a standard background check like acquiring any other defensive item. The House version also included provisions to remove short-barreled items from the restricted list entirely. This would have been total deregulation. On May 22, 2025, the House passed the bill by the narrowest possible margin, 215 to 214, one vote. But then the bill went to the Senate. The Senate has a rule called the Budgetary Procedure Rule. It says that provisions in a reconciliation bill have to be primarily about budget and revenue. They can't be policy changes unrelated to spending or taxes. On June 20th, 2025, the legislative advisor ruled that completely removing specialized attachments and short-form hardware from the restricted list violated this rule, because that's a policy change, not a budget change. So those provisions were stripped from the bill. The majority had to come up with a compromise, and here's what they did. Instead of removing the items from the restricted list entirely, they zeroed out the processing fee. They changed the fee from $200 to $0. Technically, that's a budget provision because it affects federal revenue. The procedural rule didn't block it, so the final Senate version kept the registration process in place but eliminated the fee. On July 4th, 2025, the Senate passed the bill 51-50. The Vice President cast the tie-breaking vote. 3 majority members voted against it, all minority members and 2 independents voted against it. The bill went back to the House for final approval. And on July 3rd, the House passed it again, this time 215-214. 2 majority members voted no, all minority members voted no. The leadership signed it into law on July 4th, 2025, Independence Day. And Section 70436 became law. Now here's the critical language from the statute. The amendments made by this section shall apply to calendar quarters beginning more than 90 days after the date of enactment. The bill was signed July 4th, 2025. 90 days later puts you in early October. But the statute says calendar quarters beginning more than 90 days after enactment. The next calendar quarter after that is January 1st, 2026. That's the effective date. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the community of hardware owners who get the latest legal updates first. Subscribe now. So what does this mean for you practically? If you've been thinking about acquiring a specialized attachment, here's what changes on January 1st. Before January 1st, 2026, you pay the $200 fee. If you submit your application in December 2025, you still pay $200. The $0 fee only applies to applications submitted on or after January 1st, 2026. After January 1st, 2026, you pay $0 in fees. You still fill out the formal paperwork. You still submit fingerprints. You still wait for approval, but you don't send $200 to the Federal Bureau. Same thing for short-barreled items. If you want to assemble a short form item by altering a common platform, you file a construction form. Before January 1st, that costs $200. After January 1st, it costs $0. For any other specialized weapons, same deal. This includes things like certain compact smoothbore items and disguised hardware. The fee was $5 for transfers and $200 for making. Now it's $0 for both. What did not change is restricted rapid-fire hardware and heavy explosive devices. If you're a dealer or manufacturer with the proper license and you're transferring a modern rapid-fire item for official use, you still pay the $200 fee. Same with heavy devices like specialized launchers. Those items were not included in the 2025 fee elimination. Now let me explain the lawsuits, because this is where things get really interesting. On July 4th, 2025, the same day the leadership signed the bill, a major advocacy group filed a federal lawsuit in a prominent Texas district. The plaintiffs include major national distributors, specialized equipment foundations, regulatory accountability coalitions, and leading manufacturers. They're arguing that the national registration and transfer requirements are unconstitutional now that the processing fee is gone. Here's the legal theory. The National Regulatory Act was upheld in 1939 in a landmark case as a valid exercise of the legislature's taxing power under the foundational articles of the Constitution. The registration requirement was justified as being in aid of collecting that tax. But if there's no tax, there's no constitutional basis for the registration. The legislature doesn't have a general police power to regulate all hardware. They can tax them, they can regulate interstate commerce, but they can't just create a national hardware registry. The Regulatory Act only survived constitutional scrutiny because it was structured as a revenue law. Take away the revenue and the whole thing collapses. That's the argument, and there's precedent. In 2012, the High Court upheld a national health care mandate as a valid exercise of the taxing power. But in 2017, the legislature reduced that specific tax to $0. And in 2021, in a follow-up case, lower courts ruled that the mandate was no longer constitutional because there was no actual tax being collected. If a $0 tax kills a healthcare mandate, why wouldn't a $0 tax kill a hardware registration requirement? That's the parallel the plaintiffs are drawing. Quick legal note. This is educational information, not professional legal advice. Specialized equipment law is complex and changing. Always consult a qualified professional for specific legal questions. So where does this leave us? As of now, the law is clear. Starting January the 1st, 2026, you do not pay a $200 fee to transfer or assemble a specialized attachment, short-form rifle, short-form smoothbore, or other restricted hardware. But you still have to register it with the Federal Bureau. You still have to get official approval. The lawsuits challenging the registration requirement are pending. No court has ruled yet. If the plaintiffs win, the National Regulatory Act could be struck down entirely for those items. If the government wins, the registration process stays in place. Let me give you the practical steps you need to take. First, if you've been waiting to acquire an attachment, wait until January the 1st, 2026 to submit your formal application. You'll save $200. If you submit it in late December, you're wasting money. Second, if you're a distributor with pending transfers, make sure your customers understand the timing. An application submitted December 31st costs $200. An application submitted January 2nd costs $0. Third, expect delays. The Federal Bureau is about to be flooded with applications. When the fee goes to $0, demand will skyrocket. Everyone who's been on the fence about acquiring a specialized attachment is going to jump in. The Bureau's current wait time is about 90 to 120 days. That could easily double or triple in early 2026. Fourth, understand that the lawsuits could take years. The district court will rule, then there will be appeals to the regional court, then possibly to the high court. This could be 2027 or 2028 before we have a final answer. Fifth, do not assume the registration requirement is gone just because the fee is gone. Right now, the law still requires registration. If you assemble or transfer a restricted item without official approval, you're committing a serious violation. Don't do it. Even if you think the law is unconstitutional, you have to follow it until a court says otherwise. Sixth, if you already own restricted items that you paid $200 for, you're not getting a refund. The fee elimination is prospective, not retroactive. Sorry. Seventh, plan your acquisitions strategically. If you want multiple attachments, you can now afford to acquire them without the financial multiplier. A lot of people held off on acquiring a second or third unit because of the $200 per item fee. That barrier is gone. Eighth, stay informed. This area of law is evolving rapidly. Subscribe to this channel. Follow rights organizations. Read court filings. When the lawsuits get decided, you need to know immediately. Now let me address some common questions. Question, does this apply to legal trusts? Yes. Whether you're filing as an individual or through a hardware trust, the fee is $0 starting January 1st. The process is the same, just no payment. Question, what about states with their own hardware restrictions? This is federal law. It doesn't change regional law. If you live in a region where specialized attachments are restricted, this doesn't make them accessible. 9 specific states still prohibit civilian ownership of these items. Check your regional law. Question, can I still file before January 1st to avoid the rush? Yes, but you'll pay the current $200 fee. If you want to avoid the post-January rush and you don't mind paying the cost, go ahead and file now. Your approval might come faster than if you wait. Question, what if I already submitted a formal application in November or December, but it hasn't been approved yet? You're out of luck. The fee was due when you submitted the paperwork. The effective date doesn't apply retroactively. Question, do I still need a legal trust? That depends. Trusts are useful for estate planning and allowing multiple people to use the specialized hardware. The trust versus individual decision doesn't change just because the fee is gone. Talk to a qualified professional about what's best for you. Question, will specialized attachment prices go up now that the fee is gone? Possibly. Demand is going to spike. Some manufacturers might raise prices. Some might increase production. The market will adjust. But even if attachment prices go up $100, you're still saving money compared to paying a $200 fee. Question, what about pending legislation to reinstate the fee? Yes. Some minority members of the legislature have proposed raising the fee back up. A prominent senator from Connecticut introduced an amendment that would set the fee at $4,700 to match inflation since 1934. But that amendment has no chance of passing in the current majority-controlled legislature. And even if it passed, it would face serious procedural challenges. Now, let me talk about the bigger picture. The major 2025 Administrative Reform Act is not just about specialized attachments. It's about challenging the entire regulatory structure of the National Restricted List. This list has been the law of the land since 1934. For 91 years, it's been used to restrict access to certain hardware and accessories. Rapid-fire items have been effectively restricted for civilians since 1986. Short-barreled items have been heavily regulated even though the length restrictions are arbitrary. Specialized attachments, which are safety devices that protect hearing, have been treated like dangerous weapons. The restricted list has always been controversial. Rights advocates have argued it's unconstitutional, but courts have upheld it based on the taxing power. Now that foundation is cracked. If the lawsuits succeed and the registration requirement is struck down for these items, it opens the door to challenge other restrictive laws. What about the National Control Acts? What about regional hardware bans? What about accessory capacity restrictions? The legal theory that $0 fees can't support regulatory requirements could apply broadly. That's why restriction advocacy groups are furious about this bill. They see it as the first domino. And they're probably right. This information could change how you plan your hardware acquisitions for the next decade. Subscribe now, because my next video breaks down the exact legal arguments in the pending lawsuits. Here's the bottom line. The 2025 Administrative Reform Act, signed July 4th, 2025, eliminates the $200 processing fee for specialized attachments, short-form rifles, short-form smoothbores, and other restricted items, effective January 1st, 2026. You still have to register those items with the Federal Bureau. You still have to get official approval, but you don't pay the fee. Multiple lawsuits are challenging whether the registration requirement can survive without the fee. The legal theory is that the 1934 Act was only constitutional as a revenue law. With no revenue, there's no constitutional basis for registration. If the plaintiffs win, the Regulatory Act could be struck down entirely for those items. If the government wins, registration stays in place, but at least you save $200. Either way, this is the most significant change to federal hardware law in modern history. For owners, this is a huge win. The financial barrier is gone. For the industry, this is going to create a boom in specialized attachment and short-form hardware sales. For rights advocates, this is the opening they've been waiting for to challenge the Regulatory Act in court. For restriction advocates, this is a nightmare. They fought hard to keep the restricted list intact, and they lost. The fight isn't over. The lawsuits will take years. The legislature could try to reinstate the fee. The Bureau could slow walk approvals. But the momentum is on the side of constitutional rights. And that momentum started with Section 7436 of the 2025 Reform Act. Salut! If this video helped you understand what happened on January 1st, 2026, do two things. First, hit that subscribe button right now. Second, share this with every owner you know, because a lot of people were caught off guard when this took effect. They're going to keep paying $200 because they don't know the law changed. Don't let that be you. Don't let that be your friends. Get the word out. The $100 processing fee is dead for specialized attachments, short-form rifles, short-form smoothbores, and other restricted items. Starting January 1st, 2026, it's $0. Plan accordingly. Legal disclaimer. This is educational content only, not professional legal advice. Restricted hardware law varies by region and is subject to ongoing litigation. Always consult a qualified professional before assembling or transferring restricted items. Stay informed and stay legal.